Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman.
Hi,
Mr.
Michael.
Nachman, welcome.
Thank you so much for having me again, Michael.
Very interesting subject today. Let me introduce the subject and then David has a lot to talk about that also. See, under the employment preference category, as you know, the people ask the question all the time, I want a green card, what are my options? So we look at the case on a case-by-case basis. Family preference categories, if a person is married to a U.S. citizen or green card is married to a U.S. citizen, to a person is married to a green card holder, or a brother is filing for the sister or the brother, or a U.S. citizen is filing for a married son or daughter. All these are family preference categories, but they have a lot of weighting in most of the categories. But let us say somebody has no relatives. Then we look at the employment categories, and employment categories are basically first, second, third, fourth, and fifth. Most of the people require a labor certification to qualify for an immigrant visa. So after going through the process, the decision is to be made. Actually, even that decision has to be made even in the process of filing the application for labor certification. What is the plan? Do we want to apply under employment third preference, or we want to apply under the second preference? Now, why that decision? What difference does it make with the second or the third? A lot of difference. For example, India, let's take India as an example. Employment third preference, which is for skilled workers and let's say bachelor's degree holders, the Indian cutoff date now is July 15, 2002. And somebody already done it, David. Got a labor cert, he filed the petition, is waiting. He did all this in 2006. Cutoff date is 2. We are looking at least 4 to 5 years. 4 to 5 years. Let us look at second preference. Second preference for India is July 2007, which is much better because the way they move, I would say you are looking at maybe around 3 years. So from 6 or 7 years, everybody is looking forward. Mr. Nachman, can you move me from third to second preference? And Mr. Nachman is going to say, well, let us talk about it. Let us see what degree you have, what experience you have, what kind of employer you have, what is the job offer. And then we have to make a decision whether you fit into the framework of an employment second preference. Now, the good news is, then I'm going to get it. Good news is this, that if you already have an I-140 approved in the third preference, and David or me, we say, okay, no problem, we'll do a new labor cert, we'll give a second preference petition filed. You can claim the old priority date of third preference when your employment second preference I-140 is approved, you get an old date. That means in some cases that
you'll be immediately current.
Immediately current, could be.
That's right.
Because even if the 2005, you might have done the EB3 in 2004, 2003, 2002, you converted to and boom, file a 485, you got a green card. Your turn.
That's right. Well, Michael, you're absolutely right. And I think that what we're talking about here is we're in the realm of what's called PERM. PERM is the Permanent Electronic Records Management, which is the labor certification application process that's run by the U.S. Department of Labor. And we're talking about the first part of the PERM process. We're talking about dealing with the Department of Labor and locking in a priority date and whether or not it's an EB2 or an EB3 case. And obviously, the first question that we have to ask is, what is the background that the individual has? Because if the individual only has, let's say, a baccalaureate degree, which most of our clients do, or if they only have 2 years of experience, you're only talking about an EB3 case.
However, which means, not every person who is in EB3 can go to EB2. There are certain requirements to be made, like your person is nothing, here got a bachelor's degree and 2 years experience.
That's right.
And he says, David, can you please put me in the second preference? And you may say, no, because you don't qualify. Person has to qualify.
That's right.
Not only from degree wise. You say, oh, I have a master's degree. Right. So why wouldn't I get second preference?
Right. Well, that's exactly right. We would look to see whether or not they qualify for a second preference case. So how do you qualify for a second preference case? Well, one, as Michael properly points out, is that the individual has a master's degree, or two, that they have a bachelor's plus 5 years of experience, which is identified or recognized as the equivalence of a master's degree.
So either of the two have to be there.
That's
either
correct.
master's or bachelor's and 5 years experience.
That's right. And
that should be equivalent to the U.S. bachelor's degree.
correct.
Yes.
The equivalent of a U.S. baccalaureate degree plus 5 years of experience in the field. And that's what they would, or you can ask for a foreign bachelor's degree.
That is correct.
Plus 5 years of experience.
Yeah.
But you have to be really precise in the perm application as to what you're asking for, because if you're not, what could potentially happen is that you could go through the whole labor certification application process and find out that the individual doesn't qualify for the labor certification that you've drafted. So it's critical that you spend a lot of time on the front end of a labor certification to draft a labor certification in such a way that you make sure that it entails or takes into account the individual's actual credentials.
Very good point. You know, I tell the people a different way. I say, you want to build a house, so the first thing to do is make the foundation very strong. And based upon the total plan, the foundation has to stand, no matter you go 3rd floor or 10th floor or whatever, right? Your foundation is defective, and the building is going to be defective. You will be never able to make that building that meets the requirement of the law.
Correct.
So it is very, very important. People come to me, come to David from many stages of the case where somebody has already messed up the whole case. The perm is done wrong, perm is denied, they come in. Because those lawyers did not spend a lot of time in the very beginning. People come to me for a green card, and any case, whether it's employment, whether it's family, or whichever way, I have to see I'm starting here and I'm going to end here. Can I bring my client successfully up to this point or not? What are the different stages and where we may have a problem in this case? And then make a decision like a boat. You know, I tell them that this person has to take you in the water, sea, or I mean, a river from this end to that end in a boat. And the client is a passenger in that. So we have to make sure that the client can be safely taken to that end.
Right.
I mean, anything can happen in between. I'm not saying that it can never be denied. But I'm saying at least a reasonable decision is made. Based upon this analysis, stage 1, stage 2, stage 3, you can explain more, that everything will go right. This person has the right education, the right qualification, the right employer, is willing to pay the proper wages. If the EB2 will increase the wage substantially, maybe from EB3.
Correct.
If the employer willing to pay, if the employer willing to go through the process, there has to be advertisements and all that. So very, very important that you have. Why I'm saying this? Because we every day see these cases messed up, botched, and we have difficulties in. It's easy for me and David to start a brand new case. We know the whole thing. We put the proper foundation, 1, 2, 3, and go up. Then a case that has been messed up. That more work and more time, actually. Would you say that correct?
That's exactly right.
Right.
And we had an interesting question this week from an individual who is works for a very large academic institution where he already had an EB3 case that was approved. It was approved at a low-level information technologies type of position. And then he came to our office with the request to possibly initiate an EB2 case with the hopes that maybe he could shave off a couple of years off his
Right.
wait time. And it was a very interesting question because he had the bachelor's degree, and he also had 4 years of experience with another firm, and then he had 1 year of experience with the organization that he was presently working for. So he said, can I do the EB2 case? So what would you tell him, Michael?
I said that 1 year experience with the same employer could be a problem.
That's correct. It could be a
Exactly.
problem. And
Yeah.
it's not, interestingly, by law, it's probably not a problem because the only thing that's required is the bachelor's plus 5 years of experience.
Correct.
The problem is that in the perm process, you're dealing with a computer. And the computer doesn't understand.
Yes.
Because the computer, when it looks at the years of experience, is going to pick up on the fact that one of those years is years of experience that they had with that employer. And that's where he's going to be taking a little bit of a risk. I feel that probably on an audit, he would end up being successful, but the problem is that the Department of Labor is making him wait for a year before they're going to give him an answer on the audit, so that could slow the process down.
See, the principle on why the Department of Labor from the beginning had this rule that the experience gained with the employer who's filing labor certification is generally not counted or taken into consideration. For example, the person got an H1 visa. And H1 visa time, the employer says, we only need a bachelor's degree, we don't need experience. You have a bachelor's degree, you do H1. So he works there for 2 years. 2 years down the road, the same employer files a labor certification, and I say I need at least minimum of 2 years experience for this job. The government is going to say, what are you talking about? When you hired this person for the same very job he is doing, he did not have any experience, he only had the bachelor's degree. So how can you say now that you are saying that needs a 2 years experience? The other thing, they also look at the other employees in the company. Company is still hiring for the same position, only bachelor's degree without experience.
That's right.
So the company's policy is in question then.
Right. And actually, it's an interesting thing. When I was speaking to this gentleman, one of the things that I had mentioned to him, which I gave him a different way to look at the world with regard to perm. And I said to him, I said, there are two ways you can do perm. One is that you can draft a job description and initiate recruitment through the perm process for the position that the individual actually has. That's
Exactly.
one way to do it.
Right.
The second way to do it is to be more foreseeable and to draft a job description and anticipate what that person's position may be with the organization 3 or 4 years from now.
Creative. And by creative, I don't mean coaching, don't do like this, don't like this. Creative means getting a better ideas, being creative to see if the job really is something different, more complex, that then is a whole different situation. We can adjust accordingly.
Exactly.
But obviously, we don't never say that, oh, you just do this, you do that. I mean, obviously.
Yeah, but there are two ways to look at the world.
Exactly.
So now, for example, with regard to what you're bringing up about use of experience that an employee has.
Exactly.
One of the things that could be done, and one of the things that we suggested to this individual who spoke to us, we said to him, well, here's another way to look at it. What about the possibility of obtaining sponsorship for an EB-2 case with a different employer? Because if you go to a different employer, then of course he can use all the experience that he obtained from that
I do the
that
same thing, and
employer.
actually I prefer the client goes and brings a new employer, so there's no issue at all.
That's right, but this individual said, well, it's an academic institution, so how is that possibly going to be? Because it's only one employer. And I said, well, let's pick apart the employer, because I know that most academic institutions, if you look at, if you take the onion and peel away the skins, what you find is that the employer has several different corporations under it. And what you can do possibly is utilize a different employer identification number within the same organization to do the sponsorship, and then possibly use the experience that the individual obtained with the first employer.
So there are many different ways to do it. You have to be creative, you have to use your brain, you have to put your mind in the case, and you try to figure out how best this client can accomplish the objective that he's looking for, which means moving from EB3 to EB2 in this case.
That's right. Michael, I think that the key is to be able to explain to the client all of the options, to lay out for them all of the options and let them eliminate all of the options, but at least they can see the options and see the pluses and the minuses of each one of them, and then let them make the decision.
Some other questions come in. The EB3 employer closed down. I-140 is approved, closed down or fires him. I don't think any of those things affect that. Let us say it closes down the business, the EB3 who filed it, and another employer starts a EB2, and EB2 perm is approved and I-140 is filed. He'll still get the old priority date. It doesn't have to be the same employer.
Should be able to seize the old priority date, Michael. I agree.
That's what I'm
Yes,
saying. That's,
absolutely.
yes, I know that is not a problem. As long as I-140 is approved, it's locked in, the priority date for any subsequent petition like EB2.
Right, and also I think one of the benefits of the I-140, of course, as you know, being approved in that case, is that once an I-140 is approved, the individual is able to get 3-year extensions under AC-21 on their H-1B. And that's very beneficial. And they can be pursuing a labor certification with a different employer and use the I-140 approval from the first employer to get the extensions for the
In very
H-1B.
short, we're running out of time. Somebody has an EB3 petition approved, and in August 2007, he filed a 485, which is pending. He starts now a EB2 perm and gets that approved. He can file a EB2 I-140 and continue the same case that is pending in the immigration service under second preference. So the category will be converted, the same case continues. So I think we are coming in end of the program. We thank you very much Mr. Nachman for coming here on the program, and you have
Thank
been
you,
very
Michael.
helpful today
Thanks
on
so much.
EB3 to EB2. And viewers, thank you very much for watching the program, and goodbye.